Welcome to the Regulatory Transparency Project's Fourth Branch Podcast series. All expressions of opinion are those of the speaker.
Hello, and welcome to the Federalist Society's Regulatory Transparency Project's Fourth Branch Podcast. My name is Libby Dickinson, and I am the Assistant Director with the Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. Today, we are joined by a fantastic group of tech and legal experts to discuss AI preemption. Our speakers today include Dr. Scott Babwah Brennen, the Director of the Center for Technology Policy at NYU, Kevin Frazier, AI Innovation and Law Fellow at the UT Austin School of Law, and last but certainly not least, Adam Thierer, Senior Fellow of Technology and Innovation at R Street Institute. Thank you all so much for joining us today. I'll start by handing things over to you, Kevin.
Thanks so much, Libby. Always great to be chatting about law and technology, especially on the Friday before Memorial Day weekend. So before we get to burgers and camping and tents and all that jazz, Adam, let's get into the weeds of this really fascinating part of the AI regulatory debate. So just a few days ago, you testified before the House Energy and Commerce Subcommittee on Commerce, Manufacturing, and Trade. And at a high level, your testimony was part of a broader debate about whether Congress should move forward with a 10-year moratorium on many forms of state AI regulation. And just yesterday, May 22nd, in a vote of 215 to 214, the House approved the so-called One Big Beautiful Bill, or H.R. 1, which included that language. So now with the Memorial Day weekend pending before us, we now have that One Big Beautiful Bill, including that moratorium, pending before the Senate. So let's just start with the language itself. What does this moratorium actually call for? What are we actually debating here?
Yeah, sure. Thanks to FedSoc for putting together this podcast and Kevin for you hosting. So this moratorium came about because Congress has grown concerned about the rise of a problematic patchwork of state and local AI policies. There's over 1,000 AI-related bills pending in the United States today, and Congress has grown concerned about how that might affect the free flow of interstate commerce in an algorithmic sense. So what this provision does is it basically sets up a moratorium on sort of AI-specific related state and local regulatory enactments. It is an effort to basically do what we did for the internet with things like the Internet Tax Freedom Act and other provisions of the Telecom Act, but do it now in the AI era, which is to set up a national marketplace to ensure that investment and innovation can happen without excessive constraints in a sort of parochial mother of all patchworks developing. And this is, of course, controversial, as we'll discuss today, because, of course, the states are moving very aggressively compared to the early days of the internet. When I was working on the Internet Tax Freedom Act back in 1997-98, the states were sort of very much in the backseat. They weren't almost in the car at all. They just weren't acting. But today they're really driving, but they're driving policy in a very, very heavy-handed way, and in a way that's now become increasingly concerning because of the cost and the confusing nature of all of these different laws, regulations, and even definitions. A lot of these state AI rules don't even define artificial intelligence the same way. So that's what has motivated Congress to move this provision.
And Scott, thank you again for coming on. It's great to get your perspective. I saw already, and for the listeners, we on the back end can see one another. And I could tell, Scott, at times, perhaps you didn't quite agree with that characterization of what the lay of the land looks like right now. So from your vantage point, what's this moratorium look like? What kind of gave rise to it?
Sure. Well, thanks again for having me on. I'm anticipating a very interesting conversation here. So, I mean, I think Adam's description of where it's coming out of is fair, and certainly wouldn't want to quibble with Adam's sort of understanding of what happens sort of in the back rooms of the government. The one thing there's a couple points I guess I'll make. I am very sympathetic to the concerns about a patchwork. And there's been a lot of attention recently on the fact that, according to, I think it was like multi-state, that there have been 1,000 bills that have been introduced this year at the state level. That seems like a huge number of bills. And actually, it is just a huge number of bills. They range widely. I'll say, there's a huge difference, though, between what's introduced and what is actually passed. Now, that might be a little consolation to Adam or to Kevin, to you, that, the states have only passed, a dozen or a couple dozen bills. But I just want to make sure that we're all sort of starting at the same point, which is we're not dealing with 1,000 laws. We're dealing with a couple dozen laws that, for the most part, especially what's passed this year, have been actually pretty targeted on specific or intended to address specific consumer harms. Now, to my mind, I'm sure we'll get into this, that there's a couple different sort of debates to have here. One is a sort of big picture debate about the value of AI regulation sort of writ large at this moment in time. The second is maybe the slightly harder, well, they're both hard, but maybe the more interesting one or more directly relevant, which is who should have a seat at the table when we talk about regulation? Should it just be left completely to the federal government, as this moratorium more or less tries to do? Should we include the states as well? What role should states play? And what are the relative sort of trade-offs involved in, these different sort of options of excluding the states or allowing the states to play a role?
And I want to dive into those meaty questions in terms of thinking about the timing of regulation with respect to emerging technology, thinking about the institutional capacity and the constitutional role of different actors taking on different tasks. But one thing I want to kind of flesh out a little bit more is your point, Scott. Yes, there may be 1,000 proposals, and there's a vast difference between a bunch of states thinking about EU AI Act light or EU AI Act equivalent bills that are never going to see the light of day. Let's say we have those, right? We could have theoretically 50 bills that look just like the EU AI Act that never get enacted. And yet we have had some states, namely Colorado, move forward with comprehensive AI legislation that, if emulated by just one or two, could theoretically begin to create the sort of regulatory framework and patchwork that folks are concerned about. So, Adam, I'll come back to you. Can you tell us a little bit more about the interesting conversations going on in Colorado right now? They passed this kind of first in the nation leading comprehensive AI Act. What's the debate and what's the status of that act right now?
Yeah, sure. So that's a major bill that passed last year that Governor Jared Polis signed. And that bill is an attempt to try to address so-called concerns about algorithmic discrimination. And it includes a wide variety of definitions and standards for how basically developers have to make sure that when there's consequential decisions and substantial factors, they must exercise reasonable care for high-risk applications and all of these things you can put air quotes around, because basically it's left to the different states to define these, and they do define these things differently. And then there's different classifications for where developers versus deployers versus distributors fall in the liability chain there, or the regulatory system. That's what creates a lot of confusion, so much so that when Governor Polis signed the law, he signed it with and issued a statement that was astonishing. It read more like a veto statement. And he pointed out, and I want to make sure I quote it correctly, that his law that he has passed, quote, would create a complex compliance regime for all developers and deployers of AI and significant affirmative reporting requirements. He then, more astonishingly, called upon Congress to enact a, quote, needed cohesive federal approach. And then just 2 weeks ago, he came out in favor of the moratorium that Congress is considering, although he said he'd like it to be a bit shorter. This is a big deal. Obviously, Colorado leading on this. It's been out there for a while. There's been so much confusion that they actually had a special study committee for it. They could not come up with answers to a lot of these confusing questions about how to define the things that I just mentioned. And there's even been calls by some to say we need a special session in Colorado to delay or consider the law again. And laws like the Colorado law have been pending in many, many, many states across the nation. A lot of them have been slowed or vetoed, even as the case in Virginia has been. And Texas and other states and Connecticut have revised their laws. But at the end of the day, this gets back to the point about the confusing, costly patchwork from hell. I mean, we're talking about a lot of different types of approaches and standards to something that we want to develop a national marketplace in these technologies to deal with the fact that we're in an international race with China and the rest of the world for AI supremacy. So that's what's going on in Colorado. But as Kevin, as you and I pointed out in a piece for Lawfare just a couple weeks ago, it's not the only type of law pending out there. It's just one variety of which there are many different subflavors. But then there's a whole different set of classifications of AI regulations, like things passing or moving in California last year or New York this year that have to do with model level regulation. And then there's very specific types of sectoral rules that are pending or issue specific things for AI and fill in the blank, AI in education, AI in elections, AI in whatever. And so, we're talking about the most comprehensive sort of approach to regulating a new emerging technology in the history of the United States. And that really is begging for congressional intervention of some sort.
And we know that there are a wide variety of perspectives on both sides of this issue. And I'm not even sure it's fair to say there are just two sides. This is a smorgasbord of opinions and perspectives. So, Scott, I know we're unfairly placing you in the role of representing that side, or perhaps the con in the question of should we move forward with this moratorium or not. So kudos to you for being a good sport. You do not have to be to answer for everyone that may not be in favor of this moratorium. But just so we can flesh out some of the perspectives here, do you agree with the general sentiment that, okay, if we had 50 versions or even 5 versions of the Colorado AI Act, that might be a problem? What I'm getting at here is, where do you think the proper role of the states is? Do you want to see that sort of comprehensive model regulation that we may see in Colorado or in New York, where they're considering the RAISE Act, for example? Or are you contemplating a more targeted, specific regulatory role for states?
Yeah. So thanks for saying that. You're absolutely right. Like, I am certainly not the right person if you're looking for a strong defender of the landscape of state AI regulation. To be honest, the vast majority of bills that I'm aware of, I think, are kind of dumb and quite misguided. And you're absolutely right. Like, I'm deeply worried about a patchwork. I'm deeply worried about the impact that misguided regulation will have on innovation, but I think more accurate to say on differential impact on innovation. I'm really quite concerned about how certain regulations may disproportionately impact smaller companies rather than bigger ones, worsening issues of competition dynamics. So, yeah, all that being said, right? Like, I'm not the strongest defender here of states in AI, but that being said, right, I hear a lot of arguments that begin like this. AI is a once in a generation, once in 1,000-year technology that is very new, so new that how can we really understand not only what it will look like, but how we should regulate it? That is an argument that is a starting place that I see on all sides of the debate. But to me, it seems, okay, if that is the case, then why would we want to foreclose our ability to understand different regulatory frameworks and to try them out? At core, my position here is I want to see the states involved because I think the best way to come to a productive regulatory framework is to try things out in practice. I've written a lot about the value of experimentation, about things like regulatory sandboxes. And I think that's because regulation is really hard and almost always has unintended consequences. We can debate the pros and cons of a piece of regulation, but until you try it out, it's really hard to know what it's about. Given that, I think there is a role for states to play in AI regulation. Now, you're right. Like, I don't no, I don't think states should be doing things like SB 1047 from last year, right? Significant regulation at the foundational level, and foundation models, right? Things like Colorado, I don't know. I have some real concerns about that. But I think there is a role for states to be testing out different sorts of regulations, especially when the federal government has not done a whole lot. And especially when there's a huge amount of concern across this country that there are significant harms that need to be addressed through regulation. Now, I think there's a ton to debate there, right? And regulation needs to be very careful and thoughtful, but it needs to do a good job of balancing the different trade-offs at play. But that doesn't mean that there should be no state involvement there. I think that's sort of where I end up.
And so to stick with you for a minute, Scott, as you're pointing out, this in many ways just comes down to a line drawing exercise. Where do we draw the line of where the proper role is for states in the regulatory scheme versus the federal government in the regulatory scheme? And there we run into a lot of headaches because one state bill, for example, could hit on various aspects of the AI stack, where it's regulating developers, it's regulating deployers, it's regulating users. So a single bill could raise a lot of issues, right? That then gets passed and we say, well, where does that federal preemption fall in? Which of these are preempted? Which of these aren't? So it'd be great to know, is there a definitive line you would draw where you would be comfortable with a moratorium?
That's a great question. I don't know. I've done a lot of soul searching in the past week, or 2 weeks, and had a lot of these conversations. And I had a good conversation with my co-author on the WAPO editorials Eve 2 days ago, and he, I think, convinced me that there would be some sense in a moratorium on foundation models, on regulation of foundation models. That makes some sense to me, right? Honestly, well. Again, we can have a big picture conversation about like the value of AI regulation, the value of who should regulate, but there's this conversation about like this particular provision in this bill, right? If it weren't 10 years, right, which is an incredibly long time period, right? Adam, you're talking about the Internet Tax Freedom Act. I think you would know, when it was originally signed, wasn't it 3 years? And then it was extended.
It made permanent, yeah.
Yeah. So, 10 years is a really long time, especially in a place when, like, we all know that the federal government is, let's just say, very slow here. If it were a little bit more targeted and specific, right now it covers AI models, AI systems, which it defines as just about any system that uses, I think, in whole or in part, AI, and anything that uses what I can call it, algorithmic. Here, I'll get the exact language. Artificial intelligence models, artificial intelligence systems, or automated decision systems. That covers a lot of ground. Would certainly apply to things like social media platforms. For all we know, it could apply to the ability of state governments, for example, to make rules about procurement, right? So anyway, all I mean to say is that, like, there are the big picture questions about, like, what is the relationship between innovation and regulation? Who do we want to be having a seat at the table? But there's also, like, very fine-grained ones about, like, does this provision, like, pass muster as far as leaving us in a good place in regards to regulation.
Yeah, Adam, let's hear your retort here.
Yeah, I'd love to comment on this because, look, these are issues I've struggled with for a long time. About 28 years ago, I wrote a book for the Heritage Foundation called The Delicate Balance, Federalism, Interstate Commerce, and Technological Freedom, something like that. And it was my effort to have an open sort of soul searching about where do I draw these hard lines in the world of emerging tech when it comes to constitutional first principles. And I'm someone who's usually arguing for devolution and minimizing federal power. But I also had to admit then and now that we have to have a serious conversation about what constitutes interstate commerce in the technological age that we're living in. And, algorithms like digital bits, they don't stop at state borders. They cross them. And, it's very important if you want to create a robust national marketplace in this sector or others, you've got to think hard about whether or not states should have the powers to put up borders to stop, bits or algorithms from crossing state borders. Now, I understand that there are real world outcomes that affect people in the states, and we need to address them. There are certainly legitimate concerns about AI related harms. But again, this moratorium does not affect generally applicable laws that would go after people who, in very specific contexts, utilize algorithmic systems to do harm to others, whether it's discrimination, civil rights, unfair and deceptive practices, various other types of tortious harms. We have a big toolkit to deal with these things, obviously, admittedly, in more of an ex post than an ex ante way. That's a really key part of this debate. Do we take a European style ex ante precautionary approach up front and have all of these so-called guardrails by design? We did not do that for the internet. And some people think that was a mistake. And they say, we can't allow happen to AI what happened to the internet. And what I always ask them back, like, what do you mean we should have had prior restraints? We should have had licensing in the internet and social media? Is that what you wanted? I think we need to be cautious about allowing those lines, if they're going to be drawn at the state and local level in the form of hundreds, if not thousands, of different confusing, costly approaches, because that does have ramifications for the interstate marketplace, which Article 1, Section 8, Clause 3, and many other provisions of the Constitution and much case law has clearly stated is in the realm of Congress to address. And so I'm there right now, and I'm saying, look, we either need to have some sort of a national framework with clear preemption and then carving out where states do have a role, or we need to have a moratorium to put a pause on this sort of aggressive, overzealous regulatory activity that honestly most states should not be engaged in.
Yeah.
And
Okay. Yeah. I mean, a couple things. Oh, okay. Yeah.
If I can follow up with Adam briefly, because one interesting response both to the article you and I penned, as well as to a piece I wrote for Reason, was this really fervent pushback that states should be allowed to adopt some voluntary compliance standards. That this, for example, on model development, just saying, hey, these are the best practices we want you to follow. And something that I'd love to get y'all's perspective on is, all right, let's imagine California comes up with just going to make up something hypothetically, the Safe AI Model Certificate, right? That has been verified by Stanford or run through the best scientists in California. And now they will certify certain models as California safe. But it's all voluntary. There's no requirement that you have to go and get this stamp of approval. Is that a good thing? Is that a bad thing? According to a lot of folks on X, there's no problems with that. It's totally up to you. Scott, why don't we start with you? How do you feel about this voluntary stamp of approval? Is that going to raise any red flags for you from a kind of innovation standpoint, or is that somewhere where you think states can and should play a role?
Yeah, I sense from Adam's chuckling darkly in the as you're asking the question that there's going to be a strong opinion here, but no, I mean, first I'll say, it seems like the moratorium is written that it would cover something like that, right? I mean, unless you feel free to correct me on my reading of the moratorium text, and I guess that's why you're asking the question. But no, I mean, I'm interested to hear what Adam has to say. But no, I don't have a strong issue with that, and I think well, I hope we get later on to focus more squarely on this question of the relationship between innovation and regulation. I think that seems to be sort of this key undercurrent in a lot of the discussion around the moratorium, and I think AI or tech regulation more generally. Anyway, yeah. So I'll say, we
will circle back there. But yeah, Adam, what's your take on this?
Look, I mean, when you talk about voluntary standards, you got to ask how voluntary is voluntary when, the state government in California, no less, is coming down hard on you saying, we strongly encourage you to voluntarily do these things. I don't know. I'm wondering if that's legit. And yes, I do think the moratorium might have something to do with that if it somehow took on some sort of force of law, but we'd have to debate what we meant by that in a quote quote unquote voluntary sense. But realistically, we don't need to talk about that. We just need to talk about what's actually going to be required by California and these other states, which has been pushed, and like whether or not, a moratorium should cover it. And I really do think, obviously, there are clear ramifications for interstate commerce. And, we're doing this podcast just 24 hours after there's a major, overturning of like EV requirements in California for the national marketplace. And California, the so-called Sacramento effect, has driven national policy on a number of fronts. And I don't think that's good. But I mean, you could have a better debate about doing that in the context of labor or environmental rules. But when we're talking about interstate algorithmic commerce and the internet and things like this, I think it's a far more clear-cut case that you absolutely have to have a national overlay. It doesn't mean that you can't have some carve-outs from it. You can't have some exceptions that maybe Congress gets around to once they craft a national framework. But the reality is that we don't cede that ground to the states just saying like, oh, well, it's laboratories of democracy, quote unquote. It's more like laboratories of destruction of an interstate marketplace. And Congress is entirely within its right to set some ground rules for that. They did this in the Telecommunications Act to clean up 100 years of state and local laws that made a nightmare for intrastate commerce and innovation and investment. And we finally got around to correcting that. And I'm glad we did not allow that to happen to the internet, to have 50 different federal computer commissions or internet commissions. And I don't want 50 AI commissions. I think we have to have a strong national framework here if we want this to thrive the way that I think most of us want us to do.
Yeah, what do you say to people who say a strong national framework would be great? It's just not happening.
I think that's true at the short term. But of course, part of the argument for those who support the moratorium is that it'll sort of light a fire under Congress's butt to do more on this front. I understand the people snicker at that and say, look at privacy, look at these other things. It's true. But, there's this argument that like Congress should not be setting up any sort of rules of the road when they don't have a clear replacement. I'm sorry, but that does happen. It does happen. First of all, when any industry is deregulated, look at like when we deregulated airlines, we didn't say we have to therefore have price controls now at the federal level because we're disallowing it at the state. No, we just said, no, this marketplace is going to be free. It's going to be open. It's going to be deregulated. Now with AI, I'm not saying that. We do need some rules, but we need to think about which one should be state and local and which one should be national. And some I think should be clearly taken off the table, the easiest case being model level regulation. But I think you can go further and say that basically a lot of other laws, including like Colorado's, would interfere with the interstate marketplace in a pretty big way, as even the governor of Colorado himself said in calling for a national framework. So I do believe we need to have something like this in the short term.
Yeah, but that's not what this bill is, right? Like that's not what this provision is. This isn't a scalpel, right? Like picking apart, trying to figure out like what is the best sort of balance of state and federal regulation. This is saying states should play no role whatsoever.
Well, let's be clear. It is saying that if you are going to do technocratic AI-specific regulation, yes, that's true. We're going to have a moratorium on that. If you're doing, again, let's read from the rule of construction. If you're doing things that are requirements imposed under a generally applicable law, imposed in the same manner on various systems, you're in the clear. Now, we can have a debate about what that means, but it clearly is saying that there are laws that can apply. You just can't do technocratic AI-specific types of rules that would impact the national marketplace. I do understand that's hard line drawing, but I want to be clear. It's not quite as blanket as you're painting it out to be.
So as we're moving to the close of this, I think it is useful to zoom out at a higher level, as Scott was indicating earlier, about just trying to get a sense of where the proper line is to draw in a different context, just on this debate about the pros of regulation and the cons of regulation with respect to either furthering or inhibiting innovation. So, Scott, why don't we start with you? What's the argument that regulation, properly crafted, can actually accelerate innovation, or what would that look like in an AI context?
Yeah, well, I think there's a few different arguments here. One is to say, what is the relationship between regulation and innovation? What is the relationship between regulation and innovation for AI in particular? Frankly, we don't know, right? Like AI is really new. We have very little empirical data on how different types of regulation may or may not impact AI. Like that's just how things that's just how it works, right? Like we're always sort of, empirical analysis is always going to be like a little behind the curve. From other sectors, it's a bit of a mixed bag. I think there does seem to be decent empirical evidence that in certain cases, innovation can be significantly harmed by overregulation, especially in tech. In other areas, in some areas of tech, like green tech, we see sort of the opposite happening, where certain regulations can actually push forward certain types of innovation. I think my sort of just like general takeaway here is that like it's complicated and we don't have a lot of great empirical literature on this really kind of complicated relationship between regulation and innovation. But on the other side, I think too often we over prioritize innovation without recognizing that there are other competing values at play, right? Like out in the world, like sure, innovation is really important, and we want to make sure that like we're innovating in this like exciting new area. But there are other values that we also need to pay attention to: safety, consumer safety, justice, competition, quality, user experience. These are all things that we shouldn't sacrifice entirely at the altar of innovation. And I think that's I think where I've ended up here, which is to say we want to make sure we're innovating, right, in the right ways, but also it needs to be in dialogue with these other trade-offs. And frankly, I'm okay if innovation is slightly impaired if we're talking about a potentially world-ending technology. I'm not quite sure I buy that, like the really sort of like existential level risks about AI, but certainly it is a revolutionary one. And, there seems to be wide concern, not only amongst, folks working in tech, amongst policy experts, but also amongst the sort of like general public, that they have a lot of concerns about AI. And so I don't think it's so obvious to say, like, not only must we consider the impact that regulation has on innovation, but we must also balance it with these other competing priorities.
I just want to be clear that I agree that we need to put into perspective the fact that innovation isn't the only value. And I'm not saying that. It's an important value, and innovation can, of course, save lives and lead to greater prosperity for civilization. But the reality is that harms do happen, and we need to have remedies. And I'm not disagreeing with that. But what I'm saying is that first and foremost is that we need to make sure that we tap existing tools to address those that will be more technology neutral and not interfere with the development of a national marketplace. And I just want to quote someone here who is not exactly what you would call a MAGA Republican. This is the very liberal Massachusetts Attorney General, stating last year that, quote, existing state consumer protection, anti-discrimination, and data security laws apply to emerging technology, including AI systems, just as they would in any other context. And I already went through the litany of other types of rules and regulations that are applicable to AI general laws. I'm such a huge fan of what Richard Epstein once famously entitled in one of his books, Simple Rules for a Complex World, using generally applicable law instead of technocratic specific types of regulatory strikes. So that's my first point. My second point would be, yes, there will still be other concerns and harms, and maybe even requiring preemptive approaches. But I still believe this is probably better focused at the federal level with a national framework, and then maybe Congress working with the states to figure out where their proper role is in other contexts. I understand the moratorium preempts a lot of that, but I think that's necessary. And then we get to the discussion about how to get into the detailed weeds of how to deal with those things.
Yeah. One thing,
just to exercise the moderator's prerogative for a second, because I think there's another factor that doesn't get discussed enough in these debates, which is institutional capacity. There's an assumption that states can enact these laws, and tomorrow, suddenly there are 150 AI experts or AI auditors who can just relocate to New York and suddenly enforce the RAISE Act. Or tomorrow, Boise, Idaho is going to be a hub of AI expertise. I just don't see it. And so this institutional capacity question that doesn't get asked enough is, yes, you can have great regulation. It can be well crafted, but it can be horribly, horribly enforced in a way that does hinder not only innovation, but also the values we're talking about, where, as we've seen from the EU AI Act, when you don't have proper enforcement regimes set up that are well-funded and include experts, what ends up happening well, you get kind of arbitrary enforcement where enforcers are just going for whoever looks like the most egregious actor because they're in the headlines or what have you, but they're not actually enforcing the law in a way that would align with the rule of law itself. So important consideration there. Scott, let's have you respond, and then we'll quickly go to quick forecasts. What's the Senate going to do? So Scott, go for it.
Yeah, well, I would be remiss if I didn't use this as a plug for a piece that Kevin, you and I are writing together on. So we're actually trying to address this question of how exactly do existing UDAP laws, or maybe we'll see how the piece develops, wider consumer protection laws at the state level, how do they cover the sort of AI harms that people are concerned about? And I certainly don't want to get ahead of ourselves here, but I would say, like, for me at least, it's not super clear that a lot of these laws have some ambiguity, certainly on the unfair or side of things, right? The deception is maybe a little bit easier. That like it's sort of clear what might be covered on the deception side. The unfair side of things there might be sort of more room for, Kevin, as you said, sort of selective prosecution here. So on that side, I'm actually, I think that additional regulation may help clarify the situation rather than make it more difficult. But we'll have to sort of see how that one plays out. I mean, but in the bigger sense of like, do existing state laws cover the harms that people are concerned about? It's, even aside from that, it's like sort of, right? There are a number of specific harms that are completely outside the scope of existing consumer protection or like UDAP laws. So things like, disclosure laws, right? There's no reason to think that existing consumer protection laws would require disclosure when a company, for example, an insurance company, uses an AI model to make a determination in a medical insurance case. That is something that a lot of people are deeply concerned about, or algorithmic discrimination if it doesn't already cover protected classes. Right? There's this problem I think we run into where the phrase algorithmic discrimination, like people associate that increasingly narrowly with like discrimination against protected classes. That is something, of course, we need to be concerned about, but we do have laws that apply in those cases. But there's this bigger literature on algorithmic discrimination that says that often algorithms or AI systems may be discriminating in ways that we wouldn't anticipate, or against groups that we don't even recognize as groups, right? So maybe it's discriminating based on zip code or on hair color. Those things would not necessarily be covered, right, under existing sort of equal protection laws, but are deeply concerning. So I think it's not exactly clear where the boundaries about like what existing state law covers and what it doesn't.
So obviously we still have so much to discuss, but we're running into the Friday of a holiday weekend, so we're going to have to wrap it up here. Adam, any final word, a prediction about what the Senate will do, or one thing you'll be keeping an eye on going forward?
Well, a lot of people fear that this is going to get tripped up on parliamentary requirements, basically saying that it has to be germane to a budget bill. This is all part of a reconciliation kind of package and everything. So that's going to be potentially tripped up before we even get to a substantive debate in the Senate about this moratorium. But the moratorium could come back, and Senator Cruz has said that he potentially would incorporate it into a broader AI bill he's considering, a so-called AI sandbox bill. We haven't seen that language yet, but it's entirely possible that sometime in midsummer we have a debate about this where we're coming back around to that idea.
Excellent. And Scott, any final word?
No, I mean, I think Adam is probably has a much better sense of like what the future might hold here. I'll just say, I mean, I'm looking forward to Senator Cruz's sort of own bill. To me, that seems like a much more sort of appropriate venue than kind of stuck within this massive sort of budget, so that we at least have the time to like actually have a real debate about this provision. And if Cruz sort of attaches the moratorium to an actual framework, maybe that'd be good. Right? If we can preempt state law with something, that's better than preempting it with nothing at all. So I'm very eager to see sort of where this goes in the next few months.
Well, folks, you can definitely expect another pod on this topic down the road. But for now, thanks to Adam, thanks to Scott, and Libby, thank you again for hosting us.
Absolutely. Thank you all so much for joining us today and for sharing your insights. That was a fantastic discussion and a little bit of a debate there. It's great to listen in. Thank you to our audience for tuning in today. And if you're interested in learning more about all of our programming here at RTP, discussing the regulatory state and the American way of life, please visit our website at regproject.org. That is REG Project, regproject.org. Thank you.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch Podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.